This conference will now be recorded.
All right. So we're here this afternoon going over the changes to our standard forms that will be effective on July 1st. Uh, if you get your forms any place besides Zip Forms or directly from the North Carolina Realtors website, you will need to make sure you update them. If you've set up templates in, I don't know, DocuSign or Dotloop or whatever you use, you'll want to make sure you've got the updated versions of the forms in there. I believe they give us, say, a 60-day grace period. And now you don't have to go back and change forms. If something was signed June 30th, you don't have to go back and redo anything. But going forward, you want to make sure and use these updated forms. So like I mentioned, the changes this year luckily are not super substantial, but there are some changes you'll need to be aware of. We're going to go ahead and just start off with the contract itself, 2T. And you'll see the first thing they changed here is rather than a note reminding you if there is a manufactured home, you should use the additional provisions addendum. They've replaced that with a checkbox where you are affirmatively stating there is or is not a manufactured home that's being included. And if there is, you need to use 2A11T. So next thing, small change here. They have eliminated the checkbox for by the effective date for the initial earnest money deposit. Now, by default, it's due within 5 days of the effective date. I'm sure a lot of you have encountered serious issues with sellers and buyers arguing over exactly when it needs to be delivered. They're hoping to make that a little bit simpler here, and it's just due within 5 business days. The explanation from the attorneys is that a seller could still demand it, and use form, I think it's 355T, to demand the money if you're having an issue, but they're trying to simplify that there. That's a rare instance where they have actually removed a checkbox from our forms. Minor change, wire transfers are added specifically, as well as electronic means. And obviously you can see not a lot of changes here. Fuel tanks have been removed from this section completely. It now has its own section dealt with later in the contract. It's a little more extensive. There's some extra check boxes. And over here, they have, there's always some changes that kind of make me laugh. Apparently, they needed to specify that inflatable pools are personal property. So pools do specifically exclude inflatable pools. A few minor things, they've removed the references to the tank there. The leased fuel tank does not convey, obviously. Trying to clarify a little bit here in this note, there is no loan or appraisal contingency in this contract. I know everyone over the last year has probably seen one of these appraisal addenda that claims to alter the contract. I'll tell you that so far, I've maybe seen one or two that I thought materially changed the terms already included here in Form 2T. So they're trying to clarify that. Previously, it said buyer's obligation to purchase is not contingent. Now they're trying to make that a little less passive and just say there is no loan or appraisal contingency. And of course, down here, just changing up that language a little bit for the loan process rather than for the appraisal to be completed. Again, removing references to fuel tanks here because it's being all addressed in one section later on. The property is being sold in its current condition. That part has been restated a little bit more forcefully. And they've also, again, tried to clarify some language here. Seller may, but is not required to engage in negotiations. They're not even required to negotiate, much less do repairs. So they want to make sure that's clarified so that buyers right now understand you can't make the seller do anything. This was actually, I read the reasoning behind this change, and honestly, it felt like agents and buyers really stretching. But basically, they changed this to acknowledge that you received the disclosures sometime before making the offer. Apparently, there was some I don't know, arguments over receiving it at one point and then you write the offer later. I didn't quite get what they were trying to do with this one, but they're making it clear that if you receive disclosures anytime before making the offer, you're good. The costs for HOAs. You're going to see here they have eliminated a lot of this. That's another one, kind of like the fuel tanks. They've created a new section to better clarify who's responsible for what charges. So in this section, we're just referencing section 9B, which is where this new section is now in the contract. So here we have the fuel tank section. It's not super complicated. We're basically just acknowledging that there is or there is not a fuel tank. If for some reason you have more than one, there's places for 2 boxes. You can say that it is currently in use, currently not in use. It's either owned or it's leased. And again, if it is leased, specified earlier in the contract, it obviously does not convey because of course the seller doesn't own it. Same thing for tank number 2. And they're specifying here that tanks that are owned will be included as part of the sale, free of liens, unless it's been called out as being excluded.
I have a question.
Go for it.
So I actually have a property that I'm going to be listing here shortly, and I actually called the company to confirm whether or not it's owned or leased. They said it was leased, but they said the lease is transferable, and all the new owners have to do is call them. So how is that exactly handled with this, new addition to the contract?
Yeah. So that is I don't know if it's addressed specifically here, or maybe it is. Yeah. So the note here is basically saying if it is leased, the buyer, as part of their due diligence, is entitled to conduct inspections to determine how a lease may be transferred. Because frankly, most of them, if there's a lease tank, it probably can be transferred to the new owner. These gas companies don't want to go out and remove a tank and send in a new one every time ownership changes. So yeah, that's
right. Okay.
yes, it does. The buyer has the right to find out how it can be transferred if it is leased, but if it is leased, it's technically still not part of this contract. Does that make sense? Does that answer your question?
It does.
Okay, awesome. And now it's kind of crazy to me. I realize some of these fuel tanks have large capacities, but we've probably all heard of or had a buyer who gets close to closing and they're arguing over who gets the fuel in the tank. Maybe they just refilled it and it was $800 and they think they get paid for that. It is specified. Now, this was actually in there before. The seller has the right to resell fuel to the provider, but any fuel that's in the tank at settlement is part of the purchase. And they do specify, because remember, buyers have the right to reasonable access to the property all the way through closing. That includes working utilities. So the seller's use of the fuel in the fuel tank is still subject to their obligation to provide working existing utilities through closing, or in the case of buyer possession, before closing, by buyer, before possession by the buyer. So it hasn't technically changed anything here, but it's trying to clarify this, make sure everyone's on the same page. And they've added a note here that at least in North Carolina, state law says no one can remove the fuel except the supplier or the owner of a fuel supply tank. So owners, sellers can't just say, that's fine, I'm gonna drain the gas, stick it in a can and take it with me. That's not legal. And let's see what we've got in the chat here. Are we still having folks having issues with the link to join? Okay, Craig, yeah, if you could get that. I know the original one I posted on our Facebook page is working. I'm not sure what happened when it got copied and pasted, but if you want to grab that one there, that would be great. Again, the owner association fees and charges, they've removed what was a section here, and it's included down here below. The home warranty section hasn't actually changed. It's exactly the same. What changed is that it used to be its own section. Now it is subsection N here in section 8 of the contract. And I believe the note is even the same. So the charges by an owner association, again, they're trying to clarify exactly who is responsible for what. So we'll now see spelled out in the same section, one after the other. Seller shall pay 1, 2, 3, 4 different fees here. The buyer shall pay these 3 different fees. So they're trying to eliminate disputes between buyers and sellers there. So hopefully that does help out and will help clarify things. Again, home warranty was its own section 10. They just moved it up. Condition of the property. A little clarification here that the property needs to be in substantially the same or better condition at closing. If it is not, they have clarified here that the seller must return both the due diligence and the earnest money. So previously it just said earnest money. This obviously caused disputes because I personally think it's pretty clear that if it's not in the same condition, the seller's in breach. And we know that the remedy when the seller's in breach is typically all money gets returned. So they were apparently, there were sellers who were pointing to this section and saying, hey, it doesn't say I have to return due diligence. So they've clarified that yes, the buyer may terminate if the home is not in the same condition or better, and that they must return both the due diligence fee and the earnest money. And basically they've just added a new title here for section B about risk of loss. They have, and this is kind of interesting here, they have added under the breach by seller section a provision that specifically mentions specific performance. So I know most of us have always heard that, hey, if a seller breaches and says, I'm just not going to sell, you can sue them and make them sell per the terms of the contract. It was not specifically mentioned previously that that was a possible remedy for the buyer. So they have added in here language to specifically say that this is a remedy the buyer may pursue in court. So hopefully if you ever run into that situation, you've got something now that you can point. And I believe, yeah, that's it for the contract. Before I move on to the next form, anyone have a question about anything on the contract? I am not hearing anything, so we will move on to the amendment
This VK.
to the contract.
I thought I saw something about drapery, something, which was highlighted. Maybe I missed it.
Could you say that again? I was having trouble hearing you.
There was something highlighted about drapes and drapery rods and all that. That I don't know if we covered that or I missed it.
Yeah, up there in the list. So they just curtain / drapery versus and drapery. It's super minor. Yeah, it's basically saying the same thing. Just again, every year, one of the things they try to do is clarify.
Yeah, I just saw that highlighted. Usually that does become a point of contention sometimes. I just wanted to know if I was missing something.
Yeah, it's definitely, I don't know. People get caught up on such weird small things sometimes.
Yeah.
So next we've got the agreement to amend the contract. One of the important changes up here is actually right here under the title. You can see they have added amendment number and a blank. So honestly, sometimes agents get very confused about this. They think, hey, we've already signed an agreement to amend the contract. We're done. You can't ask for anything else. You can amend a contract as many times as the parties agree. So to try and help track multiple amendments, they've added a place you can put in, this is the agreement to amend the contract number 1. If you do a second one, number 2, number 3, number 4, hopefully you don't run into many situations where you need that many of them, but just in case, you can now number the amendments to clarify the order in which they have occurred and to be sure everyone understands that all the amendments are effective. Amendment 2 does not necessarily replace Amendment 1 unless it also amends the exact same term. And now you could always change the escrow agent, but now they've got an additional spot where when you do encounter that situation, the successor escrow agent, the new escrow that has been changed from what was on 2T, can sign to acknowledge that they have received that escrow funds, that it's been transferred from the first escrow agent to escrow agent number 2. And that is it for that form. I think that one's pretty straightforward. So we will hop on over to the buyer possession before closing. So this is actually something that several of the district directors here at Fathom had questioned in the last year of the North Carolina Association of Realtors Attorneys. Previously, this form literally gave no right to the owner of the home to have a key. So you've got buyer possession and you've got seller possession. So in this case, the buyer is possessing the home before closing. It previously didn't include anything that specified that the seller, who still legally owns the home, was entitled to retain a key to the property. So that's the biggest change you'll see here. Honestly, this one at the top is relatively minor. Sorry. My phone rings on my computer too. We'll edit that out for the video. So the first change up here, relatively minor, is just specifying that there are some things not considered by this form. Security deposit, other things that would be considered by a residential lease agreement, specifically 410T. So the terms of the possession, access by seller, means of access. The seller can't just show up at the property anytime they want. The buyer does have possession, but the seller is entitled to retain a key for entry. So This is the part, like I said, this was not previously included. The seller does have the right to enter the property in the case of an emergency, and they have the right to retain a key. But, of course, once closing occurs, they turn over that final key. If the contract is terminated, because again, in this case, the buyer is possessing before closing. So if the contract terminates after the buyer has taken possession, but before closing occurs, it's specifying the buyer shall immediately vacate and return all means of access to the property, which seems fairly obvious, but they are specifying in here that the buyer does have the obligation. Previously, it said if the buyer does not immediately vacate, they will pay a holdover fee of however much per day. So this is specifying that the buyer doesn't have the right to go ahead and stay and just pay that holdover fee. They are obligated to vacate the property. If for some reason it is impossible to immediately vacate the property, then the holdover fee would apply. And that is it for that one. Any questions on that one? All right. And basically, actually I've got these not in the order I meant to. And the seller possession basically says the same thing in reverse. Buyer, because of course in this case the buyer has closed, they do own the property, they won't enter the property without the seller's permission except in case of emergency. The seller is obligated to provide the buyer with an entry key at closing, even though the seller will remain in possession. And then of course the seller will deliver all other means of access at the conclusion of the term of this agreement. So like I said, this one's just, it's the same language change, just in reverse from the buyer possession. And then we're going to move on to the listing agreement. You're going to see, number one, this language is exactly the same as the change on Form 2T. The fuel tanks have been moved to one section, inflatable pools are not conveyed, and the same slight change there with the curtains and drapery. Again, same language from 2T. This attorney fees and cost, this has been, again, consolidated into one section at the end of the form, so it's been removed from this section here. And as we get down to, again, fuel tanks, same language as Form 2T. We're not going to read through that again on this one. It's that they've just changed this to match what was changed on Form 2T. This one, they've removed the acknowledgement regarding the receipt of a copy of the question and answers on home inspections by the Real Estate Commission. And that's, I believe they've listed a reference to all publications that are publicly available on the Commission website a little later here. So here's the big change on this form. And the exact same thing will apply to the buyer agency agreement. They are trying to make it easier to fill out the agency section correctly. So you all know the original version, and to authorize dual agents, designated dual agency, you needed to initial the first blank and the third blank. Well, clients frequently would try to only initial the third blank, which makes no sense. You can't do designated dual agency unless the firm is a dual agent. So to try to make that a little clearer, we've got a new section here. They first added subsection D, which explains what designated dual agency is a little more clearly than was previously included in here. And it does specify an individual agent may not be designated to represent a party if they already have confidential information. You know, that if for some reason you were in the same physical location as a listing agent and they, you know, they were complaining that, oh my God, my seller's crazy, they have to move by the end of this month, and I don't know what I'm going to do. Somehow you bring a buyer for that listing, you can't be a designated dual agent because you know the seller's motivation, you know confidential information. So this is just specifying here that in that case, you cannot be designated to represent that buyer. So what they have done, you now have blanks for dual agency and exclusive representation. And to try to emphasize that designated dual agency is a subcategory of dual agency by the firm, they have indented the blank where a seller, in this case, would initial to authorize designated dual agency. And they have also, because technically in the previous version of the listing agreement, if a seller initialed both dual agency and the designated option, it does not specifically direct the firm to only act as a designated dual agent. In theory, it left a loophole where the listing agent can say, well, hey, you know, you approved dual agency. Like, yeah, you also approved designated dual agency, but you approved dual agency, so I'm going to represent this buyer. And so now there is a checkbox here where the seller can affirmatively authorize the same individual agent to represent both the seller and the buyer, or specifically not authorize them to do so. So most likely, when you are filling out this form for Fathom, you're going to have the seller initial this first blank. They are most likely going to check they do not authorize you to represent both the buyer and the seller. And Fathom absolutely does offer designated dual agency. So you would then have them initial this indented blank underneath dual agency to limit that practice to designated dual agency. And then, of course, if they really truly want exclusive representation, which means no Fathom agent can show your listing. If the seller selects exclusive representation, no Fathom agent can even show your listing. So I really think if you're properly explaining this form to a seller, they don't really want exclusive agency. They may think they want it, but we've got 1,200 some agents in the state of North Carolina. There's a good chance that, so a question here, yes, if your seller chooses exclusive agency, yes, you should put in the agent only remarks that it is exclusive and that other Fathom agents cannot show it. So yes, you do want to be on the lookout for that. But like I said, if you're really explaining this to a seller correctly, I think they will choose designated dual agency because they're eliminating hundreds of agents that could potentially sell their home. And then VK, so 2 initials becomes 3. So no, there's still, there's either 2 initials in section C here to approve dual agency and then designated agency. There's an extra checkbox that was not there before. So there will either be, with Fathom, there will either be 2 initials up here and a check in one of those boxes, or 1 initial for exclusive representation. So yeah, the number of initials hasn't actually changed here. Just basically the formatting has changed to try and make it more clear about what combinations are possible. And hopefully this will also help. Frankly, a lot of times when sellers or buyers got their agency agreements via, say, DocuSign, and y'all made all 3 blanks optional, one of the most common things they would do is just sign all 3 or initial all 3 because, you know, they weren't. So no, the checkbox does not need to be initialed. So you'll, the question was, does the checkbox need to be initialed? It does not. They will initial this line, check one of the boxes, and then most likely initial the second line as well. So before we leave that, I know that that's the biggest change on here. Any other questions about the changes to how dual agency is presented on the form? All right, if not, we will move on. So you saw I mentioned at various points that some clauses related to the termination or breach or attorney fees had been moved to a section later in the form. This is that section. Basically, they've put everything related to what could go wrong here in one section. So one thing they've added here is the seller is acknowledging that this agreement is a contract. That's one thing, honestly, sometimes clients get confused. They don't have any problem understanding that Form 2T is a contract, but because we call this an agreement, they think it's something that, yeah, you know, whatever, I don't want to do it anymore, I'm just going to terminate. It is a binding contract on both parties, so they can't just terminate without agreement from the firm. And of course, most of this language is not new, it's just been consolidated into one section. So you got here what happens in the case of breach, what happens, mediation is, you know, if there is a disagreement, mediation is the first method that both the seller and the firm should attempt to use to resolve it. And then the section on attorney fees, again, the language hasn't changed. They've just put it all in one section to make it a little bit more clear what happens. And this section is very rarely used, so it's not a section we're going to go through line by line here. And that is, oh, almost, here it is. So when I said earlier that they removed that checkbox for the receipt of the question and answers on inspections, they've added a note here that says, hey, if you want any of this stuff, it's available at the commission website free of charge. It's got a link. If they're using an actual PDF, it's a live link. It'll take them to the commission website. Any questions about the listing agreement before we move on here? All right, I'm not hearing anything, so move on ahead. The buyer agency agreement, most of these changes basically reflect what we just covered on the listing agreement. You know, they've consolidated that section we just looked at regarding breach and attorney fees and mediation. They have added some sort of titles here: confidentiality, standard of care, representation of others, which, you know, occasionally when there have been so few listings, we would get the question, can I submit an offer for 2 buyers on the same property? It actually is included here in section 6 under the firm's duties that we may represent buyers who are interested in the same property as you. Submission of informational listing services, just letting them know that, hey, when this closes, there's certain things we got to put in there. Again, I don't know why they removed that particular acknowledgement and not the other 2 on this form. That one seems a little odd to me, but they have removed, again, the receipt of the questions and answers on inspections. This is exactly the same as the listing agreement. The dual agency section here has been updated to reflect exactly what we just covered on the listing agreement. The only difference, and this, I always hate when the formatting ends up like this, you've got a blank at the very end of page 4, and now the subcategory for designated agency is on page 5. When you are filling these out electronically, I really recommend that you make this blank and this blank required initials. And unless you've discussed this with them up front and they want you to do dual agency for some reason, just go ahead and check does not, because it's not typically in the client's best interest. So if you want to get your paperwork right the first time, make this blank and this blank required. I know it seems easy to just make all 3 blanks optional, but the problem is clients don't read it. They either initial all 3 or it's optional, so they skip all 3, and then you're getting those rejection notices from IntelliAgent. So highly recommend, make it required, and just check does not. And 9 times out of 10, you'll be right and you won't have to change your paperwork later. Again, it's section 15 here, section 18 on the listing agreement. This is all the same terms, just with buyer in place of seller. And exact same note, again, referencing where they can find these Q&A brochures. Okay, so that one's pretty easy, almost exactly the same as what we just covered on the listing agreement. But any questions before we move on to the last form? All right, so the very last one we're going to cover is the referral agreement, and it is a super minor change on this one, but one you should be aware of. This does not happen often, but occasionally I will encounter situations where a client, we'll just say a buyer was referred to an agent. That agent realized, hey, you know what, I can't really help them, but I don't want to lose out on this referral fee. So rather than sending it back to the agent that sent it to me, I'm going to do a second referral, so that now the end agent, agent number 3, is paying me 25% and paying agent number 1 25%. So they've added a clause in here that specifically says you cannot assign this referral to another agent without agreement from the first agent. Again, super minor. It doesn't come up very often at all, but it came up often enough they thought they needed to include that in here. If you ever get a referral from an agent and you can't help that client, send it back to them. You don't need to try and, you didn't get that client on your own to begin with. If you can't help them, just send them back to that agent. Let them find an agent who can handle it appropriately. So that is what we're going to cover today. That's not every single change that there was, but these are the forms that are used most often that were changed. Any questions on any of these forms before we sign off today?